Thanks, Austin. Good morning, everybody, and thank you for taking time out of your busy schedule to join us today. It's nice to be back. We try to do these once a quarter for bankers. I've had the pleasure of doing HR consulting for a little over 15 years now, 15, 16 years. And we have a nice partnership with Bankers. As a reminder, SESCO does provide Bankers clients with telephone and email access if you would enroll into the Bankers SESCO Client Access Program. So if you have questions about that, feel free to reach out to your account manager and see if you're eligible to enroll or if they have already enrolled you. It's a great member benefit, client benefit, excuse me. So while we are doing this, let me go ahead and share my screen. As Austin mentioned, we are going to be providing a copy of the presentation for you, along with a copy of the recording. So with a lot going on kind of in the HR world, whether it's the labor market, whether there's upcoming trends, we kind of wanted to give you some updates on the legal things that are going on, particularly with Department of Labor. They actually just made an announcement yesterday that we can expect some updated information from them in the next few months. So I'll cover what that means, what the potential impact there could be. And then we're going to look at some HR trends that we're seeing nationwide, as well as more on the southeast side of things. And then I want to end on some workplace culture engagement, continued focus on recruitment and retention for employers is really, really critical this year. So we'll look at that as well. So a couple of things going on. So every 5 years, the EEOC, the Equal Employment Opportunity Commission, that is the agency within the Department of Labor that handles all of the Title VII of the Civil Rights Act charges of discrimination, harassment, discrimination. And so every 5 years, they issue what we call their strategic plan. And so they just finalized their 2023 through 2028 strategic plan. And one of the big pieces of that strategic plan is continued focus on Title VII LGBTQ rights. Now, most of us are doing annual harassment training. Some states require annual harassment training, particularly for managers or all employees. If you are not doing annual harassment training, please make sure that you are finding some sort of resource. SESCO has resources. There are online resources as well through a variety of companies, but you need to be doing it at the time of hire and then on an annual basis with ongoing employees. And, excuse me, and that harassment training needs to be current. It needs to make sure that it is reflective of the 2020 Supreme Court ruling about the definition of sex, which includes sexual orientation and gender identity. So part of the EEOC's focus area is really going to be diversity, equity, and inclusion with regard to race and gender identity. And so they have really kind of plotted out things that they are looking for with regard to policy and procedure, inclusive language, making sure that we are engaging in good culture, good environment. So Title VII LGBTQ is still a big focus of the Department of Labor right now, making sure there's equal treatment and that we are being mindful of those things. The other thing that has been coming up quite recently with a lot of my clients, I get questions on it at least once a week, is going to be about pronouns. How do we handle individuals who want to utilize pronouns or who may have different pronouns compared to how they look? Or what do we do when somebody is not using the correct pronouns? How do we address that? So all very fair questions. The EEOC specific guidance, again, was blocked, but we've got subsequent court cases going on. And again, with the release of their finalized strategic plan, they're focusing on pronouns. So a couple of things. we need to be mindful about the stance that the organization is going to take with regard to pronouns and email signatures, those sorts of things, social media profiles. Our recommendation is leave it up to the individual employee. We've had some organizations that have mandated putting in pronouns, and that has created pushback and cultural issues as well as potential EEOC violations. On the flip side, completely prohibiting it is also not recommended. So when we talk about the focus on EEO, making sure that our training and development and our culture really supports inclusiveness, but also making sure that, the proper pronouns. If I say, hey, Austin, I want you to refer to me as she, her, or he, him, we need to be respectful of that. Now, we're all human. We make mistakes. We can do our best to remember those things, but sometimes we slip up. So again, it's really about setting the expectation in the culture to have a conversation of, you know what, Austin, I'm going to do my best to honor your pronouns, but please understand that if I make a mistake, it's not intentional. And if I upset you or I make a mistake and I don't recognize it, please come speak to me so that I can take appropriate steps to try to make it right between us. Again, having adult conversations, having respectful professional conversations surrounding those things can help. It doesn't necessarily mean it's always going to resolve every single issue. There have been certain situations and cases that have arisen in the last year or so when employees, customers, managers are blatantly utilizing different pronouns or blatantly referring to somebody's gender identity as their physical identity and not necessarily what they identify by. And remember, those things would be considered discrimination under Title VII and could be subject to a charge of discrimination. Now, depending on what state you are operating in, and I'm kind of going a little off path here, but it's important to the conversation. So any applicant for employment, any current employee, any former employee has anywhere between 180 up to 300 days to file a charge of discrimination through the Department of Labor EEOC division, right? Those charges are filed electronically. You would get notice electronically, and typically they give you about 10 days to respond. Certainly, if you were to receive a charge of discrimination, feel free to reach out to SESCO with our employment attorneys, but you need to contact an employment attorney of some sort and really partner with them to make sure that we are responding appropriately. Typically, that's always going to be a request for an extension because the ultimate burden is going to fall to the employer to defend every single employment action. Perhaps somebody is alleging that you didn't hire them because they're transgender, or that they've been subjected to a hostile work environment because their manager and their coworkers continue to make inappropriate comments regarding LGBTQ and other protected rights, and they feel uncomfortable and they feel targeted. It's going to be up to the employer to defend and refute those allegations. So this is kind of my friendly reminder that we only have to hire the most qualified individuals, to make sure you're taking good interview notes, that we have a solid screening and hiring practice, and also that we're doing annual training on harassment, discrimination, but that, anytime there is an internal conflict, that we as the employer are taking swift action to investigate and to stop any alleged or actual harassing or discriminatory behavior, and more importantly, prevent it from happening again in the future. Documentation is key. A lot of times managers want to let somebody go for performance where it's not working out, or they're a troublemaker, or whatever it is, and there's no paper trail in the file, none. And they very well may have attendance issues. They very well may be stirring the pot. But when we don't have documentation to support our employment decisions, why we've made a decision not to hire or to discipline or to separate employment, it leaves us open to liability for charges of discrimination because anybody can allege anything. And if we don't have the support there, it makes it that much more difficult to defend. There are a lot of financial penalties that can be involved with an EEOC charge of discrimination. And the minimum threshold starts around $50,000. So, and that could also be, you know, punitive, compensatory damages, legal fees, so on and so forth. So be mindful of the EEO piece. It's really important. Make sure your application has a solid EEO policy, that your handbook has a solid EEO policy. Those things are really where they're focusing on as well. And other big news, DOL is very active right now. Two things. The first one is independent contractors, and the second one is going to be the wage and hour, the salaried exempt threshold. So I want to start with the independent contractors. Okay. DOL and the IRS have two different definitions of an independent contractor. Okay. Long and short, it is very, very difficult to truly 1099 somebody. Question I got not last week, but the week before was, we have a CFO who is working on transition. We've hired a new CFO. They're sticking around to kind of help out and train and develop this new CEO, help out during an audit, et cetera, et cetera. CEO wants to 1099 them. It's not going to fly. You've got somebody that was doing that exact same role that's also working on a part-time basis. They're an employee. So DOL has changed their definition a couple of times over the years. We've gone into a proposed 2021 rule, looking at different factors. They rescinded that. And so now we are in a new proposed rule, which has made it, from their perspective, they feel like it's easier to determine which individuals could be independent contractors compared to an employee. From my consulting opinion, I find that it's actually much more difficult. So they issued the proposed rule. Anytime that a proposed rule is issued from the DOL, there's a 60-day comment period in the Code of Federal Regulation. Anybody can go in, read the proposed rule, make their comments, provide their suggestions, etc. DOL is supposed to take all of that back, read through it, consider the recommendations or the comments, and then make any edits that they feel would be valid before making that a final rule. So they issued the proposed rule. November 28th of 22 was kind of the close of the comment period. Okay. So we are anticipating notice from DOL sometime before May or June. We have not heard anything on the independent contractor side with any of the revisions to the proposed rule, but once they make revisions, if any at all, and then they finalize that rule, it's typically going to become effective 90 days after they have finalized the rule. Could be the end of 2023. It could be as early as January 1 of 2024. So under the current regulation, how independent contractors are structured is using the IRS 20-factor test. Are they invoicing you? Do they have the ability to work for other people in the community? Are they setting their own schedule? Are they controlling their own work? Are they utilizing their own equipment and tools and those sorts of things? Okay, so currently there's a 20-factor test. It makes it a little bit easier. Under this new proposed rule, employers would have to use the totality of the circumstances, looking at 6 factors. First factor is opportunity for profit or loss. If the individual can negotiate or set his or her or their own pay, accept, decline jobs, choose the time, the order of preference, all of that, it could be that the opportunity for profit or loss would be an independent contractor. Now, if they don't have that control, we can't utilize this factor. Remember, 6 factors, totality of the circumstances, all in, okay? Investments by the worker and by the employer. If there are capital investments, if the worker has the ability to do different types or more work, reducing costs, again, do they have the ability to work in the community with other businesses? If they don't, and they're saying, oh, you're my only client, not an independent contractor. The degree of permanence of the work relationship. Independent contractors typically are contracted for short periods of time, okay? Project-based type work, a temporary service, outsourcing, those sorts of things. But if it is a definite in duration, non-exclusive project, then they're considered an employee and not an independent contractor, okay? Again, nature of degree and control, you know, if they are not really able to say, I'm going to do this piece, and this piece, or, you know, my schedule is going to be this, I'm not touching this, but I'll work on that. If the employer has any sort of control or say in how the work is done, it's indicative of control and therefore determinant of a employee relationship, not an independent contractor. The next one down is interesting because this next point was not necessarily part of the 20-factor test, so this is kind of new. The extent to which the work performed is an integral part of the employer's business, okay? If you are trying to have, so let's go back to the example that I used with the CFO, okay? Accounting is an integral part of the business, right? So if I'm saying, oh, I'm going to have a 1099 CFO, that's a critical, necessary, or central principle of the business. And so that would be indicative of an employee status. Last factor that they are considering is skill and initiative, whether that person is using specialized skills and performing their work or whether those contribute to a business-like initiative. So if they're highly skilled in a particular field, it doesn't seem to be the kind of skill that's contemplated. So again, it's a catch-all 6 points. You got to hit all 6 in order to 1099. Moral of the story is it's very difficult. In 99.5% of cases, when SESCO is consulted on, is this person a 1099 or not, they're really employees, okay? So we want to make sure that we're not engaging in both IRS as well as DOL liability there. All right, let's talk about the big elephant in the room, which is also part of the DOL focus area right now, is the changes, potential changes to the overtime exemptions for salaried exempt individuals. So flashing back to June of last year, the president released their spring, regulatory and deregulatory action notices. That was when DOL announced that in the fall, they hoped to issue proposed changes to what we call the white collar overtime exemption. So those are your full salaried exemptions from overtime, guaranteed salary, it's a duties test, it's an all or nothing mentality. We didn't hear anything in the fall, okay? They actually just released yesterday, and SESCO blasted it, so you may have seen it in your email blasts, that DOL is anticipating releasing the proposed changes to the white collar exemptions May of this year. Okay, we'll see if that happens. It's been delayed quite a few times since the spring. So right now, in order to even be considered potentially exempt from overtime, I have to be paid on a guaranteed salary of $684 per week. Plus, I have to meet certain duties underneath that particular exemption. So when we talk about exemptions from overtime, we've got executive, which is the easiest one to determine. I'm supervising a department or division. I've got 2 or more full-time employees that directly report to me. I have the ability to screen, hire, and fire, and I'm spending no less than 51% of my time actively managing my staff, to include performance management, screening, hiring, firing, directing work, et cetera, et cetera. Executive is easy. The next one is administrative exemption. That's commonly most misapplied exemption from overtime. People want to put their office staff on it, executive assistants on it. It doesn't work. So the administrative exemption has to be office or non-manual labor work. The individual has to be exercising discretion and judgment for matters of significance that directly impact business operations. So what does that mean? High-level decisions, very, very high-level decisions. Without oversight, without interference, they have to have the ability to make judgment calls, to make capital expenditures, to rewrite policy, et cetera, et cetera. Okay, so that's the administrative exemption. Then, of course, we have our professional exemption, doctors, teachers, lawyers, field of science degree. It has to be an advanced degree, typically master's or doctorate level. There are a few exceptions to that rule for 4-year nurses, registered nurses, not LPNs. Social workers, if they have a master's or a licensure designation, those things would work. And they have to be regularly engaging in their field of science or learning for their main functions of their job, as well as independent, discretion and judgment. Then we have outside sales. I'm spending the majority of my time engaged in sales, contract negotiation, primarily away from a physical office. And then the last one is highly compensated individuals. Now, executive, administrative, professional, all have, and there's computer exemption too. There's the computer exemption for high-level computer folks that are writing programs, doing high-level IT work. That is not going to be your normal help desk person, your generic IT person who is managing the website and issuing passwords. Okay, they got to be programmers in essence. The bulk of them have a salary guarantee. Now, the professional exemption is a salary or a fee basis, no less than the guaranteed salary amount per week. So there are some intricacies there. Again, it's an all or nothing mentality. You have to meet the salary plus duties, or else it's a no-go. So back in 2015, if memory serves correct, my years tend to blend together a little bit nowadays. But former President Obama required the DOL to go in and update the salary threshold. So it actually used to be, prior to 2015, a minimum of $455 guaranteed per week. And then they increased it in 2015 to $684, okay? So what's going on right now is, because of inflation, because of cost of living and all of these things, Department of Labor is saying, look, you've got people that are making $35,000, $40,000 a year that are exempt from overtime, and it's really not reflective of today's workforce. So they are going to be proposing an increase in the guaranteed salary amount. What that looks like could be anything. We've heard rumblings that it's going to go up to 700, 800. It could be over 1,000 guaranteed per week. And that intent is really to kind of, from the DOL's perspective, whether we agree with it or not, is intended to kind of help support those mid-income managers, mid-income individuals who might be working 45 hours, 50 hours, 42 hours, and that are lower paid, and make them eligible for overtime. So just like we talked about with the independent contractors, the DOL will issue a proposed rule. There will be an open comment period of 60 days. Then they will issue that final rule. It's going to be a repeat of 2015, where there are going to be lawsuits filed immediately upon the issuance of the final rule, and it'll delay. It's exactly what happened in 2015 and 2016. But just know that it's coming. I don't want you to panic. We will wait and see what the proposal is first, and then we can always help you craft. There are a variety of ways to make adjustments to your compensation structures. There are partial exemptions for overtime that could be applied in certain industries. So just know it's coming. What it looks like is still up in the air, but when it does come, we're happy to assist you with that. The other thing that is really, really big right now here in Virginia, North Carolina, and various states, marijuana in the workplace. Okay. Whether it's medicinal approved or recreational, you want to make sure that we are really educating ourselves on our state specific law, what that looks like, what is permitted, what is not permitted, and that we are training and educating our employees and our managers on that regulation. And more importantly, what our handbook policy says our stance is on that regulation. I'm here in Virginia, and obviously it is legal for medicinal use. You could have a state registered card. They've actually kind of removed some of the roadblocks to even having a state registered card. From a personal standpoint, individuals can have certain amounts at their home, and fine, great. But we should be drug testing. Pre-employment, post-accident, reasonable suspicion, which is a 2-person independent observation. But you also want to make sure that individuals understand what they can and cannot do per your handbook policy. Just because marijuana may be legal in your state does not mean that it is free reign, okay? You can still have a drug-free workplace policy. You can still do your drug testing. You can modify your drug testing. I have some clients here in the Southeast region that have said, look, the marijuana for pre-employment is really kind of putting a kink in our recruitment efforts. So we're going to remove that marijuana piece from the pre-employment panel, but I'm going to leave it for post-accident and reasonable suspicion. That was the happy medium for them. But please know that most people that are utilizing medical marijuana for medicinal purposes, they're going to be covered under the Americans with Disabilities Act as amended. Okay. So before you immediately say, oh, you tested positive, you're terminated, or we're going to rescind your employment offer, we need to take a step back and pause. We need to look at what medical condition do they have? How would that impact their ability to perform the essential functions of the job? And then we have to potentially reasonably accommodate that medical marijuana. Now, that does not mean that they can use it at work, be under the influence at work, those sorts of things. If they're in a safety sensitive position, perhaps you are an employer that has DOT drivers. That's going to change how we address medical marijuana for a DOT driver, because DOT has different standards. Okay. So moral of the story is check your policies, make sure they're written compliantly, that we're doing good training, and that we are pausing before administering any sort of discipline or refusal to hire or separation of employment. We want to make sure that we are not violating any sort of ADA laws, but that we are also, dotting our I's and crossing our T's there. Other trends that are going on in HR right now, a lot of push for state paid sick and or family leave laws. SESCO's fortunate. We've got clients in all industries across the country. So 2 weeks ago, Illinois actually just released a regulation that they're going to require every employer in their state to offer paid leave for any reason, not just for sick, not just for family, but for any reason. It's a mandated PTO for all employers. So most of us on the Southeast aren't running into that. Obviously, Maryland has paid sick leave. Virginia has paid sick leave or paid family leave, but for state employees, not private employers. Every year in General Assembly, they do try to introduce some sort of paid leave law. Nothing made it out of committee this year. The presidential administration just announced that they're going to be pushing for federal paid family leave. We've heard that before. We'll see where that goes. Most of us that are on this call have some form of paid leave already: sick, PTO, vacation, etc. If you're a small employer, you may not be subject to the Family Medical Leave Act. So it's a trend, and it's not that it's the worst thing in the world, but it does create some additional administrative burdens depending on how the states structure the requirements, most of which are typically a 30-hour of work minimum, where the individual would accrue it over time. Most states don't require you to front load it. Some are funded through, payroll taxes as well. I've got clients in New York, New Jersey, where paid short-term disability and paid family leave laws were paid through employee contributions and state taxes, and they kind of set it up to where they implemented the law. Everybody paid into it for 2 years prior to being able to utilize it. So we're continuing to watch every state. If you have any questions about paid sick leave, that sort of thing, let me know. The next trend is unlimited PTO. It does not work for everybody. There are certainly pros and cons to that concept. It's not a new trend. It started on the West Coast probably back in 2012, 2013. We're hearing more and more about it. I'm here in Richmond, so there are quite a few companies that are offering unlimited PTO here in the Richmond metro area. Again, it doesn't work for everybody. There are pros and cons, but that is something that we are seeing companies moving towards as a recruitment and a retention effort, but also to kind of pull off some of the liability that's hanging out on their books in terms of accruals that are already there. Now, the double-edged sword with unlimited PTO is kind of going back to the state sick leave laws. Some states require that if we have a paid time off policy, that is considered earned money at that point and could be payable upon separation. So again, if you're thinking about moving towards a more robust or an unlimited PTO policy, reach out. Happy to talk through that with you and kind of look at how that may impact a variety of factors at your organization. We're hearing a lot of push on adjustments for both states and on a national level, modifying the standard work week from 40 hours down to 32. I actually have a big client that is rolling out a pilot program with a few of their departments, and they are going to slowly be working the entire organization back to a 32-hour work week. Because of technology, because of demands for work-life balance, because of looking at how many hours a day employees are really productive, they've made the decision to do this trial. You can actually Google Harvard Business Review and Forbes. There are a number of articles out there that look at both the U.S. Trial run on 32, because there are some companies that have done it, as well as the international companies that have done it over the last year and a half. They've been doing these pilot programs to see what works, what doesn't. So that's a big push in 2023, is kind of reducing the standard work week. And then last but not least, artificial intelligence, AI, whether it's ChatGPT, you may have heard of that. That's been all over the media lately. And other, programs that may be utilizing AI for screening and hiring or performance reviews. Department of Labor's little red flag has gone off, and they're really kind of watching these AI programs and looking at how it could potentially impact or inadvertently discriminate against certain protected classes. Okay, so if you're utilizing AI, a lot of times, especially in screening and hiring, those AI programs will look for certain buzzwords. And we're seeing an uptick in cases and charges of discrimination because those programs are creating what we call adverse impact, and have been, whether intentional or unintentional, been kind of calling out people of different races or genders or what have you because the buzzwords weren't right in the program settings. So just be mindful that AI is wonderful. Technology is great, but it also has its pitfalls as well. Looking at retention in 2023, I was recently reading an article and it looked at generations, and Lord knows we can probably have a generation conversation for hours another time. But when the survey did a recent survey of the top 4 qualities that the 4 generations that we have right now, the boomers, Xers, millennials, and Gen Z in the workforce, it was interesting because all 4 of those generations picked the same 4 qualities. They just ranked them differently. And one of those qualities was really about growth and development. So you've really got to take a step back and look at how am I investing in my employees? What type of training opportunities, growth opportunities do we have? Because that's tied directly into retention. Certain generations are going to have a little bit longer tenure with organizations, but in this labor market, we're seeing rapid turnover. What would have been 3 or 4 years at an organization is now 1 to 2 years. And they're leaving because another organization down the road offers better training, or I have better career growth there. So take a look at what we're offering, making sure that we have a training and development program that employees can look at career development, career pathing, and that we have some mentorship programs there as well. Don't forget about your managers. They need training and development as well, especially on the soft skill. Leadership is still going to be one of the main reasons, if not the top reason, why employees leave your organization. Yes, money is important, especially in this market, but it's still all about relationship. If your managers don't have the right skill sets, not the technical skills, that's important, but they need the soft skills. We need to be investing in them as well because their relationship with their staff is going to make or break that department. Another thing is really a continued focus on employee recognition, whether that's a formal recognition program or an informal recognition program. Employees want to feel valued. They want to feel like I'm important to you, not just as an employee, but also as a person. And we need to really have things in place to provide appropriate feedback, annual evaluations, one-on-ones, quarterly touch points. All of those things are also important in recognizing the contribution that the employees bring to the table. Number 4, continue to work on that work-life balance, whether that be remote work, hybrid work environment, back in the office, flexibility in the workplace. That's what employees are looking for right now, regardless of what generation they fall into. Which is why some organizations are moving towards that unlimited PTO, so that, look, if I have to leave at 2 o'clock to go take my child to the doctor or to catch their school play, like, I don't want to feel like I'm going to get my hand slapped for that. It's really, really important from a retention standpoint because statistically speaking, the bulk of the workforce is burnout right now. So having that flexibility helps kind of balance that burnout as well. Another really, really big focus this year, I'm doing a lot of it with my clients right now, is you've got to reassess your compensation practices. Okay. On average, when people are leaving one company and going to a new company, they're getting anywhere between a 15 to 25% increase in their current compensation. Okay. They're asking for it, they're getting it. I'm not telling you to, go and start sign-on bonuses and all of those things, but you got to look at the market, your region, what we can afford, and what is valuable to the employees. Do a wage survey. Have appropriate labor grades and wage ranges for your employees. One, that helps with showing career pathing and how they can move through the range, but also it gives managers set parameters on how to screen and hire as well. What we're seeing happen a lot, and it has been since, the end of 2021, when things started kind of ramping back up, you've got these new hires coming in, and they're coming in at a much higher salary or hourly rate compared to people that have been with you for 3, 5, 10 years, and it's creating a wage compression. That also has implications with regard to Equal Pay Act and fair pay, and impacts your culture and morale as well. So be creative with your comp practices. On average, the 3% COLA isn't working for most organizations right now. What we have been seeing is anywhere between a 4 to 6% COLA adjustment, and then businesses going into additional performance incentives. Now, again, it's all based on affordability. You also want to perhaps challenge your benefit packages. What's actually valuable to our staff? Is short-term or long-term disability even worth it anymore? To some groups, it's not. What about the 401k? What about the health, dental, and vision? I'm not telling you to wipe out any of your benefit package. I'm telling you to do a survey and figure out, where do the employees see the value? Take that to heart. Look at alternatives, look at other options, look at creative ways that we can modernize our benefit package. Could it be that in lieu of a signing bonus, which has Fair Labor Standards Act overtime implications for hourly non-exempt individuals or salaried non-exempt individuals, perhaps I'm going to say, instead of giving you a $5,000 retention or sign-on bonus, I'm going to take that $5,000 and pay that directly to your student loans. Okay. There's also tax breaks for companies that are paying off student loans. So there are ways to recruit and retain that don't always have to be benefits or PTO and those sorts of things. If you've got remote workers taking care of their phone and telephone, their phone and internet costs, that could be a big deal. So look at additional incentives. If you have questions about bonuses, commissions, let me know. I'd be more than happy to talk more one-on-one with you there. You also really have to get a good pulse on your culture. If you have not done an employee opinion survey in quite some time, we always recommend that every 2 to 3 years that an organization is doing that, because you need to look at, where are we falling with recognition, job security, communication, values, excellent leadership, all of these things. And you do them repetitively so that we can start benchmarking. It could be a good key indicator if we have some struggles within the organization or particular leadership gaps. And that allows us to put parameters in place to merge those gaps. But also, a lot of times leadership thinks employees are happy, or thinks that, everybody likes this or doesn't like this. But if we're not asking our staff members for valuable feedback, we get a skewed sense of perhaps the pulse of the organization. There will be a continued prioritization on hybrid and remote work options. I heard an article through LinkedIn, or read an article, excuse me, through LinkedIn not too long ago that over 65% of job applicants, they're passively seeking, meaning they're currently employed, but they're looking for new opportunities, and they're only looking for remote or hybrid opportunities. So it does pose challenges if you are in an industry where you have to be in the office, because certainly, we have business to run, clients to serve, and hybrid and remote doesn't always work for every organization, and that's okay. Perhaps, if we're back in the office, then we really need to put some focus on flexibility there. Training and development, making sure that our employees have the tools for success that they need to have, and that we're really looking and supporting employee well-being, whether that be your wellness programs, incentives on your insurance premiums, employee assistant programs, doing other things like team building or bringing in lunches, or paying for gym memberships. Those sorts of things are really, really valuable in this market, both for recruitment and retention. Historically, looking at engagement needs, typically between years 3 and 5 is really where you need to re-engage staff. That's why it's so important to do your employee opinion surveys. Don't make your own. It needs to be statistical and reliable. There are a lot of organizations out there, including SESCO, who administer them and crunch the data and provide the feedback and help you work through an organizational plan to address the things that score high or low. But you want to look at re-engagement, and something that is really trending right now are what we call stay interviews. Why do you like working here? Why do you want to stay with us? What would make you leave for another job? Asking these questions, one, helps foster the relationship that the manager has with their employee, but it also helps us gain a pulse on what's important to them, and what are we doing right? So it's nice feedback there. That kind of wraps the bulk of the content today.